Welcome to our second AbleCon session, a guide to special needs trusts and Able accounts. We're honored to be joined by our good friend, Mr. Travis D. Finchum. Travis has been practicing law since 1996 and has been a board-certified elder law attorney since 2002. He is president and founder of the law firm Special Needs Lawyers, PA. Travis specializes in Medicaid qualification for aged and disabled individuals, as well as special needs trust drafting and administration. His practice also consists of estate planning, probate, trust administration, and guardianship, with a special emphasis on helping families plan for a member with special needs. He also helps families plan for incapacity through alternatives to guardianship. Travis is the account administrator for his daughter's Able United account and always provides such great wisdom and insight on this topic. Welcome, Travis, and please take it away with your presentation.
Thank you. I'm going to share my screen here and hopefully everybody can see my PowerPoint presentation. Okay. And thank you. I appreciate the opportunity always to speak with our friends through Able United and here in the state of Florida. As an attorney in Florida, we're going to be talking about special needs trusts, and I'm going to kind of give you my perspective on how they kind of mesh and how they can work with Able accounts. We'll touch on a few other topics along the way, like some public benefits, including federal benefits through Social Security, as well as some state programs. We could spend an entire program just talking about the different types of benefits that are out there. But I'm going to, again, talk about it from the special needs trust standpoint as to when you might need a special needs trust to work in conjunction with a public benefit. So we'll have a little bit of time for us, and then we're going to take some questions and answers at the end. And so with that, we're going to go ahead and get going. We're going to start off kind of with the big picture of what are special needs trusts. And so there's different categories which we're going to talk about, but there's going to be a common thread with all special needs trusts. They're going to benefit typically an individual with some sort of a disability. One of the goals of a special needs trust is to either gain or maintain eligibility for a public assistance program. That's where then we have to talk about the different programs. And of course, one of the other goals of a special needs trust is we're going to be able to give that individual who's the beneficiary some extra benefits and services that are going to enhance their quality of life so that they're not having to just get by on the public benefit program. So now we got to talk about a few of these programs, and I'm going to break them into a couple of different categories, but we're going to talk about some federal benefits and income streams. So the state of Florida does not have a public assistance program that just gives income to an individual. That's going to be on the federal side. And typically, we're going to be talking about Social Security benefits. When we mention Social Security to most families, the first thing that comes to mind is retirement Social Security. And that's what most of us know. We work, we pay into the system, we pay our taxes. And then when we reach our retirement age, hopefully is the goal, we get to our retirement age, we can then start drawing on those Social Security benefits in retirement. But there's a lot of other benefits through Social Security that are not based upon retirement, and that's what we have to talk about. The first one is called Social Security Disability Insurance, or SSDI. As the name kind of indicates, and sometimes it's helpful if we know and understand the acronyms, the abbreviations that are used, because we may use the term SSDI, and if we remember that the I stands for insurance, I think it'll help keep it straight from retirement and some of the other benefits. So as insurance seems to indicate, you've got to kind of pay for it. You've got to put money into the system. And that happens when we pay our taxes from when we're working. Some of the money in the taxes we pay goes over into the retirement fund, but they take a little bit of our tax money and put it into a disability trust fund. Where that comes in helpful is if we have an accident or something, a medical condition that prevents us from being able to work, and we haven't yet made it to our retirement age, we actually start drawing on our Social Security benefits early. And that's called disability. But you've got to pay into the system in order to get an SSDI check. And then there's a whole bunch of other rules as to how much you have to pay in and for how long. Those are credits with the Social Security Administration. But generally speaking, you've got to have 10 years of work employment. And you have to make a certain amount each year in order to get either 1 credit or up to 4 credits, or sometimes called quarters with Social Security. So you've got to work, and you have to also have recently been working. The example that I use is if an individual starts working at age 20 and works really hard and makes pretty decent money for 10 years, and then at age 30, they say, I'm going to go sit on the beach, for the next 35 years until I can retire. Well, they can still get a retirement check when they reach their retirement age, but it's going to be a smaller check because it's based upon how much you've made during your entire adult life, your entire working life. So that same person, though, if they work from age 20 to 30, and then they have a disabling event at age 45 or 50, if they wanted to try to go in and try to get their disability benefits, they're not going to be eligible because you have to have recently been working and paying basically into the system through those insurance premiums. So the SSDI benefit is a benefit of working, and we basically are getting our own Social Security benefits early. Well, what if an individual hasn't worked or can't work and put into the system? Well, there are some ways where that person can draw on someone else's work history. We're going to talk a little bit about that, but there's also a program for individuals who can't work and pay into the system and cannot draw on a benefit of anybody else, like a parent or a spouse. That program is called the SSI program, and SSI stands for Supplemental Security Income. This is a welfare-based program. This is the program that the federal government started back in the 70s that said, we've got to have a way to take care of individuals who are indigent, who are under certain limitations from both an income standpoint as well as an asset or a resource standpoint. So if we can remember that the first S in SSI is supplemental, it's designed to raise the individual up to a basic level so they have some income to pay for their basic needs. And the current, and we're in the year 2023, the current maximum SSI benefit is $914 a month. Some states will put a state supplement in there to raise, like if you're in California or in New York, because it's more expensive to live there, they'll add a state supplement to it, but Florida does not. So the maximum SSI check a person can get in Florida is $914. And so because the SSI program is a welfare-based program, I mentioned this before, it has both a monthly income limit and it has an asset or a resource limit. So this program is going to be important to know if we have an individual like who's going to be a beneficiary of a special needs trust. If we were to leave any money directly to them, we would cause a problem with their ongoing eligibility. I didn't mention about the disability benefit, the SSDI, but because we've paid for this benefit, there's no resource test or limit. As long as we have paid enough into the system, we can get a Social Security disability insurance check and have lots of money in the bank and be wealthy because we paid the taxes and we bought the policy, basically. There's no official policy that you get, but it's like buying a disability policy from the federal government. SSI is welfare, and if we have an individual eligible for SSI, then we're going to have to be careful. We can't leave any money directly to them. It will cause a problem with their ongoing eligibility. I wanted to mention one other program through Social Security, though, that's important for many of our individuals that we see in the ABLE programs. There's a Social Security benefit for sons and daughters of individuals who have worked and paid into the system, where the child, they call it, even though it doesn't have to be a minor, but it's a son or a daughter of an individual, can actually get a Social Security benefit based upon the parent's work history. That's called Childhood Disability Benefits, CDB, if you go to look them up. And incidentally, at the this PowerPoint presentation, there's going to be some resources that'll be available for it. But if you know to Google these terms, you can find a lot of information. And even on the Social Security's website, which I've got on here, which is ssa.gov, you can read all kinds of information if you know to search for childhood disability benefits. The individual is called a disabled adult child. That's again where a son or daughter can draw on a parent's work history, even as an adult. Benefits we're not going to go into a lot of detail on have to do with dependents and survivors benefits through Social Security. So there are benefits that if a parent retires or becomes disabled or passes away and they leave minor children, there are benefits for survivors and there are benefits for dependents. But generally speaking, the child's benefits stops when the child turns 18 years of age. This is the program, the Disabled Adult Child Benefit can actually continue into adulthood as long as the disability existed prior to age 22 and the child has remained basically dependent upon the parent. What that means is that they didn't go out and work and get so many credits of their own that they now vest in the Social Security system. Also that they haven't married an individual. If you get married, you break the cycle of dependency on your parent, and you may not be eligible for the childhood disability benefits for the disabled adult child. But like Social Security disability insurance, the DAC benefit has no financial test. So again, you can be wealthy and have lots of money in the bank and still qualify for the DAC benefit because the parent paid for it. We paid that when we paid our taxes. So that program, because it's not based on financial need, we don't necessarily need to have a special needs trust to maintain that program. Remember, if one of the goals of a special needs trust is to gain or maintain eligibility for one of these programs, the DAC benefit and the SSDI benefit, you don't need a trust, again, to qualify for the benefit. We still may need a special needs trust if we have an individual who just can't manage or handle the money, but if the goal may not be to maintain or gain eligibility. On this slide, the SSI program is the big issue. That's the program that gives that monthly check of $914 per month maximum to the individual. And it also comes with an extra benefit, which is going to be over on the next screen. So we're talking about income here. The next benefit is going to be, or the next program we're going to talk about are services, some of our public assistance programs, and in particular, medical coverages. I'm going to mention 4 of them. And there's more of these that are out there, but these are the main ones that we seem to deal with. Medicare, and most of you probably at least have heard of, know the basic ideas of Medicare, but Medicare is typically our healthcare program for individuals who are 65 years of age or older. But in order to qualify for Medicare, we have to have either paid into the system, into the Social Security system, and gotten enough quarters so that when we reach retirement age, we can get Medicare. But we also can get Medicare if, again, we've paid enough into the system and we become disabled. So that SSDI program that we talked about on the last slide, that program is tied with Medicare. So that an individual who is disabled and not able to work, but has paid enough into the system, can actually become eligible for Medicare after a statutory waiting period. The waiting period to qualify for the Medicare once we start getting a disability check is 24 months. The next medical program I wanted to talk about is Medicaid. Medicaid is tied with that SSI program, the welfare-based program that provides a maximum check of $914 a month. The majority of states have a state policy that says if an individual living in that state gets at least $1 of SSI, so anywhere between the $1 and the $914 maximum, any amount of a check will automatically trigger Medicaid medical benefits for the individual. So for many of our families, the SSI is nice and it's not bad to be able to get up to $914 a month, but we're also looking to get medical coverage, Medicaid in particular. And so we're oftentimes just applying for SSI, working with the federal program through Social Security in order to get medical coverage. You can also get Medicaid and not be eligible for SSI, but Florida has not expanded Medicaid like many of the other states have. There still are a handful of states who have not expanded Medicaid to be for individuals who are just indigent. In Florida, you have to have another category that you fall into in order to get Medicaid. And for Medicaid in Florida, it's disabled. You have to be disabled or elderly to get some of the Medicaid programs. There's a family track for Medicaid where you just have to be a minor child and then be under certain resource and income limits, actually income limits for the family, and you can get family Medicaid. But Medicaid is generally tied with being disabled. So even if you're not pursuing the SSI program, we still have to sometimes prove that a person is disabled if they're under the age of 65 in order to get Medicaid. So again, sometimes just the SSI application is enough. And SSI is for people who are under the age of 65 and disabled, or just 65 and older. And so Medicaid medical coverage is tied with SSI. There's also the Medicaid waiver programs, and there's Medicaid programs that provide for long-term care services, things like that. And there's also a specific Medicaid program that helps cover individuals with intellectual and developmental disabilities. It is specifically designed and tailored to meet those types of unique needs. It has housing allowances and transportation. In Florida, this Medicaid waiver program is administered by the Agency for Persons with Disabilities, APD. And you can learn a lot about that program by searching the Florida Agency for Persons with Disabilities. And the program is currently being called the I-Budget. It stands for Individualized Budget. So I-Budget. And that program has, because it's a Medicaid program, it has income and asset or resource limits for it. So we have to be careful about that. I wanted to mention the Affordable Care Act, which is private health insurance. And in Florida, this is a very popular program because we did not expand Medicaid. So at least now we can get private health insurance for individuals, even if they have a pre-existing condition. And that has always been a big issue and a problem in the past because insurance companies could exclude certain medical expenses if the condition already existed before you applied for and got the insurance. Well, pre-existing conditions has been eliminated from all insurance programs now. So we still do want to see about sometimes exploring private insurance for individuals. So that's about all the time we have for the different public assistance programs. But basically, the two that we're focusing on is the SSI program because it has resource limits and the Medicaid programs as well. So we're going to focus on those. So for SSI and Medicaid, there are different criteria to be eligible. Some are financial. Some have to do with medical necessity, like you have to be disabled or you have to be 65 years of age or older. And they do have that resource test, which means you can't have too much either of money or resources available to you. And there's also monthly income caps as well. And these programs are pretty sophisticated in how they were established because they recognize that someone may be over the resource limit and they want to qualify. So they may say, here, take my money. I'm going to give my money away, and therefore I'll get under the resource limit. Well, for both SSI and and the Medicaid waiver program that we were talking about, there are penalty periods if you transfer assets. So giving away resources can cause you to have to wait for services. And when we talk about resources, as a general rule, trusts, when there's been a trust established, it counts toward the resource limit. So the trusts we're going to talk about today are the exceptions to the rules. So they have to fall into one of the exceptions in order to not be counted toward the SSI and the Medicaid program. So again, we could also spend a whole half a day talking about trusts and all the basics, but in essence, there are three parties to every kind of trust. There's whoever is setting it up. We call them the settlor or the grantor. That's who's establishing the trust. We have the trustee, which is going to be the manager of the trust. That's who's responsible for the day-to-day administration, making sure that the rules are followed, and accounting for the use of those funds to the beneficiary, which the beneficiary is who it's all about. We've set up this trust for someone's benefit, and they're the one that's at the focus or at the centerpiece of all this planning, that we're trying to, again, help that individual qualify for benefits, enhance their quality of life, and doing those kinds of things. So in the special needs trust world, there are two broad categories of special needs trusts. And the categories are based upon the source of the funds. Where did the money come from that's going into this trust? It's either going to be a self-settled trust. That's when it's the beneficiary's money that's going into the trust. Or it's going to be what's called a third-party trust. That's when it's somebody else's money. It's not the beneficiary's money. And for a lot of you families that are here looking at ABLE accounts and looking to learn more about special needs trusts, the third-party trust is the one that you might be thinking about. Is, well, what am I going to do with my resources when I'm gone? How am I going to leave them for my loved one without jeopardizing benefits? Those are third-party trusts. But we shouldn't lose track of, there's a whole other category called self-settled or first-party trusts. Well, why would that be the case? Well, realize that not every individual who might be the beneficiary of a special needs trust, they may not have been born with that condition or that disability. They may have acquired the disability at some point in their lifetime. Maybe they had a traumatic brain injury or a car accident in their 20s, 30s, 40s, or 50s, and now they have become disabled, and they've worked, they saved money, and so we've got to worry about protecting their funds. Maybe that accident that they had results in a lawsuit, and there's a personal injury case, and just like the commercials say on TV, if you've been injured because of someone else's negligence, you should sue them, right? And so people have lawsuits and they collect a personal injury award. And then the other third category, other than they've worked and saved, they had a lawsuit, is that maybe there was an inheritance that wasn't planned correctly. So it was someone else's money, but it didn't get properly put into the trust, in which case it becomes the beneficiary's money because they were named directly on the life insurance policy or the retirement account. And it's too late now for us to try to head it off and have it go into a third-party trust. So self-settled and third-party. What I've got here, and it's a little busy, but this is a chart that I kind of developed for a flow chart as to what are these different kinds of special needs trusts. And if you see, we start here at the top, and the first question is, whose money is it? And what we can basically do is we can draw a line right down the middle. These are where the two categories of trusts go. We have our first party trusts, again, when it's either a personal injury award or an unplanned inheritance or something that we just didn't do correctly, and now we're dealing with it. And then we have the third party trust. That's when it's the parent or someone else setting up the trust. So each one of these round kind of ovals here is a different kind of special needs trust. So we're going to start off and first talk about the ones that are over here in the third party trusts, and then we'll finish up with the first party. So third party are kind of easier to understand and easier to explain, because this is mom and dad or grandma or grandpa, whoever is wanting to set up some money and says, I want to leave some funds for this individual that can't manage or handle the money. Maybe they're on SSI or Medicaid or one of those programs, and I don't want to mess up the benefit. So I put the money into a trust. These trusts can be there for the lifetime of that beneficiary. And when the beneficiary passes away, it can go to other family members or other beneficiaries. It could go to a charity even if we wanted to do that. And so contrasting that with the other category of first party trusts, there is no Medicaid payback in a third party trust when the beneficiary passes away. We're going to talk about that when we get over into the first party trust, that one of the conditions of being able to keep your benefits and keep that personal injury award or keep that inheritance that wasn't planned is we have to build in these Medicaid paybacks. But that doesn't apply for a third party trust. There could be multiple levels of beneficiaries, and there's no payback that's required. So we can set up the trust and we can fund it now. We can embed this trust within an estate plan. It can be within your will, or it can be within another type of trust that we use in estate planning that says, when I'm gone, rather than giving my daughter Lillian her inheritance outright, I got to keep it in here and I got to protect her for these benefits. So we can say who we want to be the trustee, how we want those funds to be handled. And so sometimes finding a trustee is a challenging job because somebody's got to then be in charge of that money for the lifetime of that beneficiary. Sometimes we can have a sibling do that, but we need to think about a long-term plan with doing all that. And so also, depending on the amount of funds, there are pooled trusts where we can deposit funds in there that's administered with other dollars so that it's not as expensive. And now we have enough money to maybe have a professional trustee, a professional investment advisor who can oversee it with smaller amounts of money. So there are pooled third-party trusts that are out there too. The self-settled trust, I already mentioned that these might be from an inheritance or a personal injury award or earnings and savings. And I'm not going to go into a lot of detail on these trusts because they are pretty technical, but I wanted to give you a little bit again of language and terminology. Sometimes these kinds of trusts that are called special needs trusts are referred to by the last 3 digits of the federal law where they're found. So they're found in the Social Security Act, which is 42 United States Code. And there's a D4A, a D4B, and a D4C trust. The D4A trust is for an individual who's under the age of 65, and the funds are protected. So the individual, let's say they've had an accident and there's a lawsuit and they've recovered $500,000 and we want to protect those funds. Those funds, if the individual is under the age of 65 and the individual is disabled, can go into a D4A trust and be there and be used for that person's benefit for the rest of their lifetime. But remember when I mentioned before, you can't give away the money and get SS and keep SSI or Medicaid, one of the Medicaid waiver programs. So they don't let you give it away when you receive it or during your lifetime. You also can't give it away when you pass away unless you pay back the Medicaid services that have been received. So there is a payback provision or a concept in all of these kinds of trusts. The federal government says, we'll let you keep the money and you can keep the benefit, but you can't give the money to somebody else. At least you can't unless we're paid back for the Medicaid. So Medicaid has a lien against these trusts when an individual passes away, but not the SSI check and benefits. So if you've received SSI for 20 or 30 years, there's no payback of those monthly checks. It's only the medical services that are covered through it. The other one I wanted to mention is a D4C, which is a pooled trust. I mentioned there's a pooled trust on the third party side. There's also a pooled trust over here on the self-settled or the first party payback provision. And again, the idea of the pooled trust is maybe my amount of money by itself isn't enough to entice a professional to get involved and want to handle it. But if I can combine my funds with others, it might be more cost effective. And now I can have a professional and can oversee it. And in this first party, the D4C pooled trust, those have to be established by federal law by a not-for-profit corporation. So we have charities that run these pooled trusts, and they can be very cost effective and be a great alternative if we don't have another trustee who's available. So finishing up our special needs trust, and we're going to spend a little time talking about an ABLE account and how they compare and contrast with a special needs trust, are that we kind of talked about the advantages. You get to keep the money and you get to use that money to provide a better quality of life for the beneficiary. Sounds great, doesn't it? And we can keep the government benefit in place. Disadvantages are we can't use the money for others, so there's some kind of restrictions. And we talked a little bit about it can be hard to find a trustee that's going to be here for the lifetime of this beneficiary. So we need to have multiple layers. And if we're going to have professionals or corporate trustees, we got to make sure that they're willing to do it for whatever the amount of money is. If there's enough zeros at the end of the balance sheet, you'll have lots of options. The problem is if it's less than $1 million or sometimes even 500,000, it's hard to find a trustee who will handle that, at least from a professional standpoint. And we talked about the fact that for the first party trusts, they are subject to that Medicaid claim or lien when the beneficiary passes away. So up until 2014, which is now coming up a little bit a while ago, it's been 8-9 years ago. These were the only options that we had to be able to leave funds for a person with special needs without jeopardizing their benefits. And I'm sure, hopefully, many of you know a lot about ABLE accounts, but ABLE accounts came in as an additional tool that we need to know about. ABLE stands for Achieving a Better Life Experience. They were signed into law in 2014, and it took a little while for the states to get ramped up because they're administered at the state levels, and Florida's was started in July of 2016. And I hope you know this because you're here on the website and attending, but Florida's ABLE program is called ABLE United, and it is administered under the Florida Prepaid College Board. So the ABLE account is actually a tax law and not a Social Security law. So it's found under the Internal Revenue Code in Section 529, which is where educational savings plans are found. And so it's a type of an educational savings plan that doesn't have to be used for education. Sounds kind of strange and kind of different, but it's a great idea for individuals who aren't maybe going to go away to college, and it's a way for families to save, and it's a way to shelter some resources. So for the ABLE accounts, you can have up to $100,000 in them before the ABLE account starts counting toward the SSI limit. And you can have even more than that in the account if you're not worried about SSI because maybe you're getting that DAC benefit. And I'm just trying to stay on my Medicaid or my Medicaid waiver program. So you can have a lot more money, over $400,000 in the account. One of the limitations are that under the current law, you have to have been disabled prior to the age of 26. Or at least your disabling condition has to have existed prior to age 26. That age is being raised to age 46, but it's not going to be phased in for another few years, actually 3 more years before the age of onset disability will go up to 46. There is not an automatic Medicaid payback. The way that Florida, at least as far as I know, the way that Florida is dealing with ABLE accounts when an individual passes away, after all expenses and outstanding payments and bills have been made, they're releasing the funds back to the individual beneficiary's estate, which if they're under the age of 55, there would not be any Medicaid claim or lien. If they're over the age of 55, there could be a Medicaid claim that we have to look at. You can only have one ABLE account. You can actually move your ABLE account from one to another, but you're only allowed to have one. There is an annual contribution limit, which is it's whatever the annual gift tax exclusion amount is, and that currently is $17,000. Plus, you can put in some additional funds if you have earnings. Not quite another 17,000, but it's kind of getting close to that. But you can put a good bit of money in, but there are going to be some limitations. If you get $100,000, you're not going to be able to get it all into an ABLE account anytime soon. Florida's, you open the account online at ableunited.com, and the ABLE account, like a good special needs trust, is exempted basically for any program that has federal funding, which is the SSI program. It's Medicaid, food assistance, subsidized housing. And as long as you use the money in the ABLE account for what's called a qualified disability expense, the ABLE account is exempted. And here's a list of all of the qualified disability expenses, though it's not an exhaustive list. There's probably lots of expenses on here that could be considered a QDE, but these are some of the big ones. I just call your attention to the very last one that says basic living expenses, which can be just about anything. It's hard to find expenses that don't fall into a qualified disability expense, but one would be paying an expense of someone other than the beneficiary. I'm going to pay for my brother's divorce, pay the lawyer for my brother's divorce. That's not going to be an allowable expense. You can't, and buying gifts and things maybe for other individuals. But other than that, we can fit just about anything into a qualified disability expense. And what happens then, as long as we use it for a qualified disability expense, the money in the ABLE account, one is it's exempted, and two, any growth that has occurred on it grows tax-free, which is a big deal. So you can have tax-free growth. The last slide that I have is doing a comparison between the different trusts that we've talked about. We've talked about the two self-settled trusts, which are the D4A and the D4C pool trust. We've talked about the ABLE account, and we've talked about what we call third-party special needs trusts. So what I've tried to do with this chart is try to compare advantages and disadvantages. It's not a Christmas chart. It's designed for green is good and red is maybe not so good, and orange is kind of in between. So you can kind of look at these where who can establish the account if we want the beneficiary to be able to establish. The beneficiary can establish all of the things we've talked about except the third-party trust. And the ABLE account is the only one that has annual limits and contribution limits. You can put as much as you want into the other trusts. We talked about the Medicaid payback. When it's a first-party trust, there's Medicaid payback. If it's a third-party trust, there's not. Medicaid payback with an ABLE account could be under certain circumstances. We talked about the growing tax-free, which is helpful, certainly for the ABLE account. Special needs trusts do not grow tax-free. Just a couple of the other ones, like lower fees, the ABLE account is going to be a lot less expensive. But again, there's going to be limits as to how much you can put in. One of the big differences between the ABLE account and all of the special needs trusts is that the beneficiary is considered the owner of the ABLE account. And if the beneficiary has capacity, then they can access it. Whereas with the special needs trusts, none of the special needs trusts allow the beneficiary to actually be the trustee. So the beneficiary can't control any of the special needs trusts. Otherwise, the trust doesn't work. And so that's an advantage if we're trying to protect a person who might be vulnerable or susceptible to influence, but it can be a disadvantage if we want the beneficiary to have that level of control and that level of access. So with that, I'm going to end it up because we wanted to leave time for questions. And so I appreciate your time. My contact information is here on the screen. My firm has our website has a lot of information. Anytime I do a talk anywhere in the state or even out of the state, I put my materials on the website so you can go back through and look at prior presentations that we've done. So with that, I'm going to end it and open it up to the questions. And should I stop sharing then? Is that okay?
Yeah, go ahead and stop sharing screen.
Okay.
Thank you so much, Travis. That was a wonderful presentation and overview on special needs trust. As always, we get a lot of questions on this topic, so we'd like to address them now. And first and foremost is this presentation is being recorded and it will be posted on our YouTube page in the coming days so that you can refer back to it and review this important information.
Great.
So one of the first questions is, how does someone find a special needs attorney, someone like you that can work with them and their family?
That's a great question. There are several organizations where we all tend to congregate together. And depending on where the individual is, here in Florida, we don't have a specialty for special needs planning. Most of those attorneys that do this are elder law attorneys. So if you go and look on the Florida Bar's website for elder law attorneys, you can search for attorneys that are board certified in an area of specialty. There certainly are good lawyers that aren't certified, but if we've gone through the level of getting board certified, it means that you have devoted more of your practice to this area. You've had some background, both screenings from a referral standpoint, meaning other attorneys and judges have to evaluate you and approve you and recommend you for certification. And you have to go through a test actually to test your skills. So the elder law section, and the reason for that is, like we talked about, a lot of these benefits and programs are Social Security and Medicaid, and they are the same types of programs that our elders will use to help our younger people with disabilities. So I would look for an elder law attorney, and then at the bigger level, the Academy of Special Needs Planners, which is a national organization, is really where the attorneys that specialize in this kind of stuff are very active. So those are the two.
Perfect. So we get a lot of questions on reporting. So if someone is a guardian for an individual with a disability, do they still have to report an Able United account if they have a special needs trust?
So if an individual has a special needs trust and an ABLE account, if we're talking, depends on who we're talking about reporting to, but yes, if we have an individual on the SSI program with Social Security at the federal level, they have to report both the ABLE account and the special needs trust to Social Security, because Social Security has to evaluate it to make sure that it is not a countable resource, that it was done correctly. Again, if they're on that DAC benefit or they're on Social Security disability, you don't have to report to Social Security because that program is not going to be impacted whether they have a trust or not. And then at the state level, if they're getting Medicaid, you've got to report to the Department of Children and Families, both the ABLE account and the special needs trust. And since there's a guardianship in this question, you're going to need to make sure whether your court is also going to want to be involved in the oversight or the accounting of both the ABLE account and the special needs trust.
That's right. That's great. I believe you touched on this on the last slide, but can a beneficiary be a trustee of a special needs?
Yeah, no, a beneficiary cannot be a trustee. Otherwise, they have access to the account and it's not protected. So we have to have someone else be the trustee. And incidentally, if they're married, their spouse should not be the trustee either, because them having access could cause a problem. The ABLE account, is different. A beneficiary can have control and access to their own ABLE account as long as they have capacity and they're not under a guardianship, but not for the special needs trusts.
That's right. And in that same vein, can you have a subsequent beneficiary in a special needs trust?
You would always want to have a subsequent beneficiary named in a special needs trust, even in the trust that has the Medicaid payback, because sometimes there's still money left in there after a payback has occurred. We have that pretty frequently, actually. If an individual puts money into a payback trust and they pass away sooner than we might expect, there may be a good bit of money left, and the lien may be pretty small. So we still may have enough to pay the lien and release the funds. But remember, on the third party trust, there is no lien. So we always want to have the next layer of beneficiary, because whatever's left in there when the primary beneficiary passes is going to go to someone or to an organization. So we always want to have beneficiaries named.
Yes. That's right. Great. This is a very common question that we get to on ABLE accounts. Does the special need trust have to pay taxes?
Yes. The short answer is all special needs trusts are subject to some kind of taxes. Now, whether the trust pays the tax or the beneficiary may actually be responsible for the taxes depends on the kind of trust. But any growth, both interest and dividends and things like that, that occur within a special needs trust has to be reported on the trust's tax return. And if there are taxes owed, they're going to have to be paid. But in most circumstances, the trust can pay the taxes and the beneficiary doesn't have to pay them personally.
That's great. All right, let's see. We have time for a couple more questions. And again, want to remind everybody that all of our sessions are being recorded, so you can review the information on our YouTube page in the coming days, and we're going to work behind the scenes to get all of the questions answered. But let's close out with just a couple more questions. Travis, can you set up multiple special needs trusts for one individual or a beneficiary?
The answer is yes. In fact, there's often going to be multiple, at least two kinds of special needs trusts, because remember, it depends on the source of the funds. So we might have inherited funds that the parents have left. And if the beneficiary ever has accumulated or received funds during their lifetime, they may have another trust that has the payback provision. So it's not uncommon at all that we have those two. And when those two are up and running, we would always want to pretty much spend the beneficiary's trust first because of the Medicaid payback provision to it. But we have that. And then here's where it's even great. There could also be an ABLE account in addition to that. And you can actually fund the ABLE account out of either one of the special needs trusts. And so we often do that. That's a great planning tool. If we want the beneficiary to have control of some funds, but maybe not the whole thing, we can put money and fund the ABLE account from any one of these special needs trusts, even the Medicaid payback one. That's right in the Social Security or in the IRS regulations that talk about you can fund an ABLE account out of any kind of special needs trust. So yes.
Awesome. And let's answer just one more question. How often should a special needs trust be updated?
That's a tough one because I have to give the lawyer answer as it depends. But it can depend on a lot of factors. But depending on the type of special needs trust, the broad categories, and I didn't go into great detail, but when it's the beneficiary's trust, generally speaking, those trusts can't be amended or changed. They're irrevocable. Now, we can build in some language that if we need to make a change because the law has changed or there's a problem with it, we can fix it. But generally speaking, we can't change those. When it's a third-party trust and the parents have set it up, I like to set them up so they can still be changed by the parents as often as they need to. But at some point, the trust is going to get locked in so that nobody can come back and change it. And that's because we want to ensure that it's there for this one beneficiary and that nobody can change. But I would say review it as often as you might review an estate plan. Certainly if there's a major change that happens, a birth, a death, something major with anybody who might be named in the document. But every 3 to 5 years is probably pretty typical. Having said that, if you did the document and the following month somebody passes away, it's always a good idea to relook at it to make sure that we're addressing everything. And if we've done a good job, we've tried to keep these trusts as flexible as possible so that we can go back and make changes if something really unanticipated comes up. And that's the challenge really in drafting special needs trusts. There's such a long-term plan. We've got to try to build in some flexibility, even though something may not be done for another 50 or 60 years from now when the beneficiary is older. Thank you.
Well, thank you again, Travis. If we didn't get to your question, we'll be working over the next few days to get back to everyone. We'll take another 5-minute break before our next session on Social Security. See you soon.